When you decide to bring a medical malpractice case against a careless doctor in New York, what is the biggest mistake that you can make that will get you into trouble? You want to know the answer? Come join me for a walk along the beach, actually near the beach, as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, you decided to bring a lawsuit against your careless doctor claiming that he was careless and that his carelessness caused you significant harm and injury. And now you want to know, what are the problems, what are the risks, what are the pitfalls that you might expect as you decide whether or not to go forward with a case? Well, first thing you should know is you have to have a medical expert confirm that you actually have a valid basis for a case. Assuming you get past that point, now, the biggest problem you are going to face when you decide to bring a medical malpractice case against a careless doctor or careless hospital staff is thinking that you know more than the attorney that you have hired to represent you. That is going to be the biggest dilemma and the biggest problem you are going to face. Some of these injured patients think that they know much more than their attorney. They think that they know how to prosecute a case like this. They think they know the best strategies in which to entrap a particular doctor into giving up all of the answers that are favorable to them. And they think they know what is best in terms of settlement strategy. They think they know what's best at trial in terms of what evidence needs to come in and what evidence should be kept out. Does any of this make sense? The answer is no, which is precisely why you hire an experienced medical malpractice attorney to help you and guide you in this path along your litigation journey, because that's what this is. It is not a sprint, it is a marathon. And if you are not aware and don't have the experience and the knowledge and the understanding into what should happen and how it should happen and why it should happen and the mechanics of actually making it happen, you, as the injured patient, as the injured victim, as the client, are going to create more problems for you and your attorney. The moment you start telling your attorney what to do, that creates a barrier. The moment you start dictating to your attorney what he can and cannot do based upon your perception of what should be done, that creates conflict. That creates a barrier between you and your attorney and your ability to communicate effectively. And now you are going to try and hamstring and tie your attorney's hands. Why? Simply because you think you know better. So a smart attorney is going to turn around in that instance and ask you a few questions and ask you for how long you've been in practice handling these specific types of medical malpractice cases in New York. Why? Because he wants to know if you have experience. Not just whether you brought a lawsuit in the past, and not just based upon your historical perspective of what your other attorney may have done in a different lawsuit. That's not important. Why? Because a medical malpractice case is significantly different than a personal injury case, than a negligence case. It involves separate rules. It involves separate laws. You have to know exactly what they are. And you have to know that the procedural rules are different than in a negligence or in a personal injury action. Now, what's a personal injury action? A case involving someone who tripped and fell, a dog bite case, a premises liability, a property damage case. All of those are significantly different. And if you have had experience handling or being part of any of those types of cases, I will tell you right now that a medical malpractice case in New York is significantly different. And the rules are different. And if you don't follow and adhere to the specific rules, you are going to have significant obstacles in proceeding forward with your case. Don't think for a second that just because you might have some experience or you might have some knowledge of the law, that is going to permit you to override and overrule what your attorney has to say. Now, I'm not saying you shouldn't have conversations with your attorney about what you think is the best strategy. That's perfectly acceptable. But to go ahead and say, listen, we are not going to sue this person. We're not going to go after this person. I don't want you introducing this evidence. We're going to keep out this evidence. Don't tell them about this. Now you've started to create massive problems for yourself and your case and your relationship with your attorney. Because believe it or not, you actually have to have a long-term relationship with your attorney. And if you and your attorney cannot and do not get along, guess what? there is a good chance that your attorney at some point is going to turn to you and say, I'm done, I'm fed up, I'm tired of you telling me what to do. I will not have that anymore, and I'm going to fire you as my client. And then they will ask the court for permission to disengage from your case, to leave your case. And then you're going to have to try and find another attorney who's going to continue representing you. And from everything that I've told you right now, if you continue that path, it's going to be extremely difficult to find another attorney who's willing to work with you in that instance. So why do I share this quick information with you? I share it with you because sometimes I encounter a potential client who thinks that they know more than an experienced attorney. And in that instance, you know what I'll tell them? Before I actually become their attorney, I say, I don't think I'm the right attorney for you. I think you want to handle this case on your own. And I strongly suggest you don't do that and try and find an attorney who is the right fit for you. I recognize you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, but you have not yet started a lawsuit and are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.